Hello, dear student. Please confirm whether my voice is audible or not. Hello, dear student. Please confirm. Hello, dear student. Please confirm my voice is audible or not. Yes. So everything is okay. So we'll start. Yes. Dear student, very good evening to all of you. So, dear student, please confirm me whether my voice is audible or not. Everything is okay or not, so that we'll start our session. So, please confirm me once. So, dear student, let me tell you one thing. So, main objective of this discussion is not only finding which one is your answer. So, here we are going to do the in-depth analysis of the question, and all possible questions from here they can ask for prelims. So, we are going to do in-depth analysis of all these questions and their answers, so that it is going to be helpful for your prelims examinations. Okay? So, we'll do daily 1 hour of analysis. We'll start our session daily on 5 p.m. to 6 p.m. and we'll do 20-25 question daily, and we'll try to cover everything related to this question if possible. Okay, so that is what going to helpful for your prelims examination, and we are going to do the analysis of last 5 years. So this is very topic wise. So from today we are going to start from the politics. Okay? So let's see the first question. So which of the following statement is not correct in respect of constituent assembly? So before starting, in question of OPSC, lot of error are there in their question, and they are multiple time they're asking not correct. So you have to be very careful while attempting this question in your examination. So which of the following statement are not correct in respect of constituent assembly? So the elections to the constituent assembly was held in 208. Yes, this is also right. Muslim League own 73. Yes, this is also right. But princely state own 93. But you know that princely state they don't contest election, rather they are allocated seat and the basis of they are giving representation. So this statement is wrong. So answer should be only 4. But I don't know. OPSC may be confused. So this answer they have given is A. Okay. So this is what controversial question. So you should know that there is a mission that is being British sent to the India. It's called cabinet mission. Cabinet mission propose a plan for constituent assembly. So constituent assembly consisting of member are elected, or you can say elected indirectly by provincial legislative council. Provinces member are elected by people on a limited franchise. Okay. So first there is a limited franchise people, they elected the provincial legislative council, and this provincial legislative council they elected to the constituent assembly, and this is elections to the constituent assembly held in July August 1946. Yes, this is right. And Congress won 206 and Muslim League 73. This statement is wrong, but I don't know, there is a wrong in the question, and I think कैसे question बना रहे मतलब OPSC केमिति question बने उसी मूवी जानी पड़नी मतलब कौन को नशा पी की भगवान जाने. So this is what a wrong question, but answer is that July August 1946 election. So Congress won 208 and Muslim League 73. 93 seat allocated to the princely state. Okay? There is no election in case of princely state. So next important question is which of the following matching are not correct with respect to schedule and they are subject in Indian constitution. So it is talking about schedule and they are what are the mention in that schedule. So schedule 2 emolument of the Comptroller Auditor General of India. Schedule 3, allocation of seat in Council of State. So I think you know that. So this is Schedule 4. So Schedule 4 is provided for allocation of seat. So this is wrong. So next one is about the administrative control of schedule area. It's 5. It is 5, not 6. So it is also wrong. So first constitutional amendment, yes, this is what enacted to the schedule 9. So these two statements are wrong. So that is 2 and 3. So answer is B, 2 and 3. So for your answer, I'm just giving you detail all the schedules. So please read it. First schedule is talking about state and union territory, name and their boundary. So name and boundary is in first schedule. Second schedule talking about special power and salary of, remember very carefully, president, governor, speaker and deputy speaker of Lok Sabha, chairman and deputy chairman of Rajya Sabha, Supreme Court and High Court judges. So Supreme Court and High Court judges. So CAG is also drawn the salary same as the Supreme Court and High Court judges or Supreme Court judges. So that is the reason it is coming under this Schedule 2. Okay. So Schedule 3 is deals with oath and promises of all authority except the President and Vice President. So you have to remember. So Schedule 3 is deals with oath and affirmation of all the authority except President and Vice President. Schedule 2 deals with detail except about president and governor, speaker, deputy speaker, chairman, deputy chairman, and Supreme Court and High Court judges. You have to be very careful. Nowadays, they are asking very factual question. Next is Schedule 4 is talking about allocation of seat to the Rajya Sabha by different state. Okay. So Schedule 5 is talking about schedule area and schedule tribe administrative area other than the northeastern state. So allocation, it's talking about administration of schedule area and schedule tribe other than the northeastern state. And Schedule 6 is talking about the administration of the tribal area of Northeast Assam, Meghalaya, Tripura, Mizoram tribal area. Okay. So next one is 7th schedule is talking about division of seat, the list into 3 lists, union list, state list, and concurrent list. 7th schedule is provide for division of subject into union list, state list, and concurrent list. So dear student, here we are going to do in-depth analysis of all the question, all the incident, so that it's going to be very helpful for your examination. So Schedule 8 is talking about different language that is being provided. So list of language in Schedule 8. So now, as of now, 22 languages are there. So there Assamese, Bengalis, Gujarati, Hindi is there also. Kannadi, Kashmiri, Konkani, Malayali, Manipur, Marathi. So Nepali is there. So you have to remember, sometimes you think that Nepal may not be there. So Punjabi, Sanskrit is also there. So Sindhi, Tamil, Sindhi is there. Tamil, Telugu, Urdu, Bodo, Santhali, Maithili, and Dogri. So these are actually 22 language in the 8th schedule. So 9th schedule provide for certain law that are put in the 9th schedule so that it cannot be challenged in any Supreme Court or High Court. If any law is put in the 9th schedule, that cannot be challenged in any court of law. Okay? But I think you already know about Supreme Court in IR Coelho case say that any law that is being placed after 1973, the post Keswanand Bharati case, they can also subject to the judicial review. So Schedule 9 is provide for saving of certain clause from judicial review. 10th schedule, I think no anti-defection of MLA and MPs. 11th schedule is talking about panchayat, and 12th schedule is talking about power of municipality. So dear student, please comment in the comment box everything is okay or not. Anything discussion, suggestion, you are always welcome, because without your suggestion feedback, it's very difficult for me to understand. So please keep interacting me and put your suggestion, which is very valuable to me. So next important question is, which of the following statement are correct in respect of electoral college in India to elect the president of India? So which of above is correct regarding the elections to the president of India? So it is consisting of elected member of Legislative Assembly of National Capital Territory of Delhi and Union Territory of Puducherry were elected to the electoral college by 70th Constitutional Amendment Act. Yes, this is right. So both the Delhi and the Puducherry, they have the contribution electoral college or the legislative assembly contribute for the elections to the president. It is under the 70th Constitutional Amendment Act. The number of and value of the vote are based upon the population of 1971 census India as for 42nd Constitutional Amendment Act. Yes, this is also correct, because so to ensure there should be population control by all the states, and states that has been control the population, they should be rewarded. So we have freezed our census to 1971 and by 42nd Constitutional Amendment Act. And this census will be again will count after 2026. any census that is going to be happen 2026. After that, we'll reallocate seat and vote to the each and every state. So that is the reason our government is currently planning to conduct the census after 2026, so that they can allocate seat as per the new census. So 84th Constitutional Amendment Act fixed value of voter based on the current population of 2011. No, 84th Constitutional Amendment Act, they provide allocation of population 2001. So according to 84 Constitutional Amendment Act, fix the value of the vote based on the current population of not 2011 but 2001. Okay, so if you eliminate 3, so 3, and you know that 1 and 2 are correct, so we'll get the answer C. Okay, so answer is C. So I've already given it. So if you look into how electoral college of the president election, you'll find that all the elected member and Rajya Sabha electoral college consisting of elected member of Lok Sabha, Rajya Sabha, Legislative Assembly of the state and Legislative Assembly of Union Territory of Delhi and Puducherry. So elected member of the both house are of the parliament, and elected member of the state Legislative Assembly participate in the election of the president. So tell me in the comment box, during impeachment of this president, whether elected or nominated member of they participate or not. So it's your homework. So please comment in the comment box. So I think next important question is, which of the following statement are correct in respect of genesis of doctrine of basic structure of the constitution? So from कोठू आमर जो डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन आसिला तारी ऊपर एक क्वेश्चंस टा अछि. सो आई थिंक यू ऑलरेडी नो दैट द Kesavanand Bharati case is the origin of basic structure of the constitution. So this doctrine propounded by the Supreme Court in Shankari Prasad Sharma versus Union of India. It's wrong. It is started from the Kesavanand Bharati case. So Sajan Singh versus State of Rajasthan, Supreme Court held that Parliament could amend any part of the constitution. Yet, yes, in Sajan Singh case, we have said that Parliament can amend any part of it. But in Golaknath versus Union of State of Punjab, Supreme Court ruled that Article 368 lay down the procedure to amend the constitution, but not an absolute power to the Parliament to amend any part of the constitution. Yes. So in case of Golaknath case, Supreme Court overturned its earlier verdict in the Sajan Singh case. It is said that though Constitution mentioned Article 368, it is provide only the procedure. So it is not giving absolute power to the Parliament. They cannot amend any sections to modify the Constitution. Okay? So 2 and 3 are correct. So next is in case of Vaman Rao versus Union of India, Supreme Court says aside the basic structure of the doctrine. No, in Vaman Rao, it is reaffirmed. That means it is accepted once again. Yes, basic structure is an integral part of our constitution. So option 4 is also wrong. First is wrong. So 2 and 3. So B is the answer. Okay. So I've already given you about the detail about it. So some of the basic feature of the constitutions. So like judicial review, federalism. So just go through it. You'll get a lot of things. So already how it is evolved, like Sajan Singh versus State of Rajasthan, I've already given in depth, in detail. So here our discussion is not only about giving the answer. We'll go and analyze on in depth. So if you have any suggestion, please go ahead and put in your comment box. I'll make a video according to that. So doctrine of basic structure was first founded in Supreme Court in Kesavanand Bharati case versus Kerala. So you have to remember the date also. Sometimes they can ask about case, and they'll ask about arrange in the ascending order or descending order. So the doctrine of basic structure is not mentioned in the constitution. It is a judicial innovation. Judiciary, they invented that, not explicitly mentioned in the constitution. So ensure the constitutional supremacy. This principle ensure that the essence, true value of the constitution cannot changed by the constitutional amendment. So balance the parliamentary power with the judicial review. So it is balancing so that Parliament cannot misuse its power to make itself powerful. So component of the basic structure include supremacy of the constitution, sovereign, democratic, secular character, rule of law, separation of power, judicial review, federalism, parliamentary system of government, harmony between fundamental right and DPSP, free and fair election, unity, integrity of nation, and independent judiciary. Okay. So different cases. Let's see. So first is started with the Sajan Singh versus State of Rajasthan. Supreme Court held that Parliament power to amend the constitution under Article 368 include authority to alter any part of the constitution. So in Sajan Singh case, it is said that Parliament can amend any part of the constitution to modify the fundamental right. So next case in Golokanath case, so Supreme Court said that no, this power is not unlimited. It is reasonable and restriction. So Parliament cannot amend all part of the constitutions. So Parliament cannot amend fundamental right. Court held that the amendment power under Article 368 not extend to altering or abridging fundamental right enshrined in the Part 3 of the Constitution. So reaffirm in the basic structure. So Vaman Rao case, Supreme Court again reaffirm. That means accepted that yes, basic structure is integral part of our Constitution. Okay. So next important article. So in this way, we are going to discuss not only about the answer, but in depth how our Constitution is evolved, what are the cases, what are the unique things. So please watch till the end. You'll get a lot of insights. You'll get a revision of your concept also. So which four article of Indian Constitution among below given article were added to the Indian Constitution by 42nd Constitutional Amendment Act 1976. So first of all, this question is wrong. I don't know how you OPSC, such a constitutional body, making such a blunder. I don't know how they are making such a wrong question. But whatever maybe, so we'll see all the amendments. So there is no article like 40, 24A. There is nothing like that. Yes, 39A is there. The next 39A is there, and 43A is there. Then 48A is there. 144A is there. Article 233 is there. So 39A is talking about access to justice and free legal aid. Yes, we have added that in. I have already written it. So I'm just reading it out. Please listen carefully. 42nd Constitutional Amendment Act 1976, also called as mini constitution. Why it is called mini constitution? Because so many provision we have modified, so many provision we have added. So because of that, it is called as mini constitution. So first we have added Article 31C. So that is what provide for implementation of the DPSP. So if it violate the fundamental rights, so that is given DPSP more power. So DPSP more power and override over Article 14 and 19 and 31. Okay. So next is about the Article 39A. That is what provide access to the justice and free legal aid. So next one is about the Article 43A. So it is talking about participation of worker in the management of industry. So promotion, voluntary organization and participation of worker in management of the industry. So this is very revolutionary because we are letting worker to manage the industry. So socialistic principle. So next one is about the 48A. So state to protect and promote environment. So next one is about 51A. It provides fundamental duties. Okay. So fundamental duties. So it is provided. So Article 144A. So this article, Supreme Court to issue order or direction matter concerning disputes or questioning law involve state governments, union government or interstate government. So 144A we also added. So Article 324 is provide for establishment of administrative tribunal. So very first time we have enacted to establishment of administrative tribunal for faster disposal of the cases. So some discrepancies there already in the option. So because or the answer is 3, 4, 6, 7, 8. There is nothing like that. So but as for OPSC, answer is B. So there is wrong. This question is wrong. Okay. So let's see next question. So which of the following statement are not correct in respect of Union List 7 schedule of the Constitution? So there are 100 subject. Yes, there are 100 subjects. So Union List is having 100 subject. State list having 61. And concurrent list is having 52. So you can see 0, 1, 2, 0, 1, 2. You can remember that 100, 61 and 52. Okay. So first statement is correct. Second statement, this list give the union list. There are 3 lists: union list, state list and concurrent list. So union list signifies centralized tendency. It is signifies federal. And concurrent list signifies cooperative federalism. Because more subject we are putting on the central list, that means we are making our more centralized, more unitary nature, not cooperative nature. If you are putting more subject on the state list, that means we are favoring more federal character. If you are putting more subject on the concurrent list, that means we are favoring cooperative federalism. So the option 2 is not correct because union list is mainly aimed to promote centralized tendency. If more subject, more power is given to the union government, that means we are favoring unitary government. Okay? 2 is not correct. So here there are 15 subject in union list on parliament has exclusive power to tax levy. Yes, this statement is very correct. There are 15 subject, but now we have added more. So Supreme Court has no jurisdiction over the matter in the union list. No, Supreme Court is having jurisdiction on all the list. Okay. So this statement is not wrong. So only 1 and 3. So So I think yes, it is given. Which of the following is not correct? Not correct. So whenever you see anywhere it is written not correct, so just highlight so that you know. Otherwise, देखो, you can either tick A. If you are not able to study, not correct. If you are not focusing on the word not correct, you will tick A. But in reality, it is answer is D na. So you have to correct. It is asking not correct. Not correct is D 2 and 4. Okay. So already I have given everything what I have told to you. So you can see about three list: union list, state list, and concurrent list, and residuary power. So defense, atomic, foreign. So war, peace, banking, railway, post, telegraph, airways, so foreign. So these are coming under the union list. Important subject are part of the union list. So union legislator can make law on it. So defense, atomic energy, foreign affair, war, peace, banking, railway, port, telegraph, airway, port, foreign trade, currency, and coinage. Okay. So next one is about the state list. State list is comprising of agriculture, police, prison, local government, public health, land, liquor, trade and commerce, livestock, animal husbandry, state public service. So these there can be a very good question. They can give list of the subject and ask which of above are part of the union list, which of above are part of the state list, which of above are part of concurrent list. So you have to identify it. Normally, only state legislator can enact on this law. So concurrent list that both center as well as state can enact the law. So these are education, transfer of property other than agricultural land, forest, trade union. So trade union is concurrent list, forest, agriculture, and transfer of property. Then adulteration, so adoption and successions. So here both state and union government can make law. So residuary power means anything that is not mentioned in any three list is called residuary power. So both the union, so here only the union. So the residuary power is exercised by only the union. So all matter not mentioned in any of the list can be fall on the union on the residuary power. For example, cyber law, any new subject that emerge. So union legislature or central government can make law on the residuary power. Okay. So next important question is about which of the following are non-constitutional bodies. So bodies are three types of constitutional. Constitutional bodies are such body that is mentioned in the constitution. And statutory bodies are such body that is being established through the act of parliament. Act of parliament or state legislator. So it is in the constitution. The next is non-statutory body. That is established on the executive resolution. Executive. Just like Niti Aayog. Niti Aayog, it is not mentioned, either constitution nor any law. It is simply established by the government. Okay. So tribunal, yes, tribunal is already a constitutional body. It is established under Article 323A for administrative tribunal, 323B for any other tribunal. So National Investigating Agency we have established in 2000A under NIA Act. So I'm erasing it. So to write, so please note down. Otherwise, I will. So NIA Act. So next is the Competition Commission of India, CCI. CCI is established under the law 2002 Act, Competition Commission of India Act. So it's a statutory body. It's a statutory body. So so this is a constitutional body. So non-constitutional body. So it's not a constitutional body. It's a statutory. Okay. So next is Law Commission of India. So we already know that Law Commission of India is executive body. So it can be established by the government without having any law. So National Commission for Scheduled Tribe, it is Article 338A. So Article 338A 38 provide for National Commission for Scheduled Caste, National Commission for Scheduled Tribe. So Comptroller Auditor General of provide under Article 148. So it's a constitutional body. Okay. So this is this is constitutional body, this is constitutional body. Okay. So I'm just writing it down in a proper way. So listen very carefully. So tribunals are added to our constitution in 42nd Constitutional Amendment Act. So original constitution, we don't have any tribunals. So this is provide for two article. Article 323A provide for establishment of administrative tribunal. Article 320B provide for establishment of tribunal other than administrative tribunal. ठीक है. So Article 302 provide for a tribunal for taxation, foreign exchange, industrial labor, land reform, and sealing and property. ठीक है. So and elections to the parliament, food stuffs, rent and tenancy act. So they can ask about Article 323B provide for establishment of tribunal under which of the following matter. You can simply refer to it, write it down. So NIA is a non-constitutional body established under the NIA Act 2008. So it's a statutory body. So Competition Commission is also established under the Competition Commission of India Act 2002, also statutory body. So Law Commission of India is a ad hoc body established by the government anytime it's needed, required. So National Commission for Scheduled Caste, Scheduled Tribe is a statutory body. So Comptroller Auditor also a statutory body. So I have given a list of all the statutory body of India. So please go through it. All the constitutional body of India. I'm just reading it out. Please listen carefully. So Security Exchange Board of India is a statutory body. National Human Rights Commission (NHRC). National Commission for Women is a statutory body. National Commission for Minority is a statutory body. National Green Tribunal, and it is established, which date is also mentioned here. Okay? So you can see SEBI is established under 1992. NHRC is established under the NHRC, National Human Rights Protection Act 1993. National Commission for Women is established in 1990. So National Commission for Minority Act is established in 1992. National Green Tribunal is established in 2010. So please listen and read carefully. So I'll provide this PDF in our group. So please take that. So Armed Force Tribunal is established under the Armed Force Tribunal Act 2007. UIDI, Unique Identification Authority of India, is established. UIDI authority or Aadhaar Targeted Public Service Delivery in 2006. Central Vigilance Commission is established in Central Vigilance Commission Act 2003. So National Commission for Air Quality Management is established through ordinance. Later on, we have established the law also. So National Commission for Protection of Child Right. So NCPCR 2005. So Competition Commission of India Act 2002. National Legal Service Authority Act 1987. So NABARD Act 1981. Okay. So next is list of the constitutional body. Supreme Court of India, I think you already know about it. Election Commission of India, UPSC, State Public Service Commission of India, Comptroller Auditor General of India, Finance Commission of India. Please read the article also. So Supreme Court is provided under Article 124 to 147. So Election Commission of it 324. So Union Public Service Commission 315 to 323. So Comptroller Auditor General of India provide under Article 148. So Finance Commission under Article 280. So National Commission for Scheduled Caste 338. National Commission for Scheduled Tribe 338A. Then National Commission for Backward Class 338B. So Attorney General of India under Article 76. Remember very carefully, 76. So Advocate General of India 165. State Public Service Commission same as UPSC 315 to 323. So Special Officer for Linguistic Minority 350B. So Interstate Council 263. So next is about the Article 243K. So it is provided state election commissions to Article 243K. So you have to remember state election commission is established under Article 243K. So dear student, please everything is okay or not, all is going well, please comment in the comment box. So next you can say about also it's provided for under Article 343YK. 243 Y and K is provided for establishment of the state election commissions. State Finance Commission is established under I, 243I, 243Y also. Okay. So the tribunal we have established in the 42nd Constitutional Amendment Act. So under Article 323A, 323B. So yes, so I have given a comprehensive list of details. So please read it very carefully. Okay? So this is going to be very helpful. So recently one more body we have established. It's called GST Council. I think 279A of Indian Constitution provide for GST Council. So GST Council is also a statutory body we have established under the GST Act. Yes, very good, dear student. So for your comment, please keep on commenting. Otherwise it's very difficult for me to understand what's going on. Okay. So if you have any suggestion, any feedback, you are always welcome. And after this discussion, I'll provide this PDF in our Telegram, in our WhatsApp also, so that you'll all get, and please revise it. It's a very comprehensive talk. So if you revise it, you'll get a lot of insights. It will just help you revising topics and concept also. So which of the following statement are not correct in respect of Election Commission of India? So कौन सा statement correct नहीं है? So Article 327 give power to the Parliament to make provision with respect to elections to the legislature. Yes, Article 327 given the power to the parliament to make provision with respect to election. So second statement is saying that besides the election commission, two additional election commissioner appointed for the first time in 1990. No, it is first time appointed in 1989. So UPSC is playing with the date also. So here the correct, whichever above is not correct. Okay, whichever above is not correct. So first one is correct. So you can also get the answer. So first one is correct. So that means for A already we have get the answer. A is the correct. Okay. So again we'll see. So Election Commission Amendment Act 1990 made Election Commission a multi-member body. See, the act is again 1989. It is not 1990. So date they have changed. So the decision of the Election Commission by the member are made by unanimous. Not, it is not unanimous. Rather it is by vote, by majority. So let's say three members are there. So Chief Election Commission, Election Commission. In case of any dispute, so they have to vote. So which side having two vote, that party will be win. Okay. So so only so this statement is wrong. This statement is wrong. This statement is wrong. So it is asking not correct. So answer is A. Okay. 2, 3, 4 because one is correct. Okay. So you can see already I have given you detail whatever I have said you. So next important question is impeachment. The impeachment of the Indian president in the parliament is a political procedure, legal procedure, quasi-judicial procedure, none of above. It's a quasi-judicial procedure because here the legislature, the parliamentarian, they participate in the impeachment. That means they are doing the judicial work, but they are not judicial. So whenever it look like judicial function, but not, that is not judicial. That is what called quasi. It is look like semi-judicial function. Okay. So I've written it about detail about the procedure for impeachment of the president. So listen very carefully. So procedure for impeachment of president is quasi-judicial. So and president can impeach. President can remove from the constitution on the ground of violation of Indian constitution. So parliament. So parliament, is government body that can impeach the president of India. So Article 61 is talking about impeachment of the president. So impeachment, for impeachment, what we need. So so you can impeach on the ground of violation of the constitution. So it can be introduced by either house for impeachment. Okay. So 1/4 for that, 1/4 member of that house need to be frame the charge and they need to be given 14 days notice to the president, and impeachment resolution set to the other house to investigate the allegation. Once it is passed by the 2/3 majority, initiated charge of the impeachment. So first house can frame a charge. Before framing, they need to provide, they need to have support of 1/4 strength of the house to submit the impeachment process. So once that is being given, so and they need to pass also 2/3 majority, and second house form a committee. That committee second house investigate, not form committee, second house investigate the impeachment, the motion. So allegation of the impeachment resolution set to the other house to investigate the allegation. Once it is passed by 2/3 majority of the house, initiated the charge of the impeachment. So during this impeachment process, so president is also having the right to participate, right to defend, everything is there. So once it is passed by the 2/3 majority, so it is only 2/3 majority. Let's say 2/3 majority means total strength. How much total strength out of 2/3? Not, it is not that 2/3 plus 50%. It is not like that. Only 2/3 present, 2/3 of the majority needed to impeach the president. So important point here, note that a nominated member can also participate in the impeachment process. So though nominated member are not participated in the election process, but they are participated in the impeachment process. So the elected member of state legislature, UT of Delhi and Puducherry, they not participate. Okay. So I'm just reading it out once again. So president can impeach on the ground of violation of the constitution, and for that 1/4. So for that 1/4 of the member of the house that has framed the charge of the impeachment should be signed the charge, and president should be handed over notice of 14 days. Once impeachment motion is sent to the other house to investigate the allegation, once it is passed by the 2/3 majority of the house which initiated the charge of the impeachment. So first house first submit 1/4 signature of the total person, and same sent to the president with 14 days notice. After that, they need to pass the resolution with 2/3 majority. Then it will send to the second house. Second house investigate, and then if it is passed with 2/3 majority, then president start impeach on that point. Okay. and only the both elected and nominated member participate in the impeachment process, and only the parliament is participate in the impeachment process. State legislature are not participated. Okay, so chaliye, so next, which of the following statement are not correct in respect of Advocate General of India? So I think you know that Advocate General of India under Article 165, he is the highest of constitutional office under the the highest legal or law office of the state also. So Advocate General is the highest law office of the state. Yes, this statement is right, but it is asking not correct. Listen very carefully. So he is appointed by the governor on the advice of Chief Justice of India. No, there is no need for any advice because he is the person from the government. So he is the person from the government. So to ensure separation of power, there is no role of the Chief Justice of High Court because he is the representative of the government. He is representing and fighting the case before the High Court also. So if Chief Justice appoints, so there might be conflicting of interest. Okay, so he would be eligible to appoint as a judge of High Court. Yes, this statement correct. A member to be appointed as Advocate General of India must be qualified to appoint judge of the High Court. He should not be more than 65 years. No, there is no such criteria. This criteria is for the Supreme Court judge. Okay, so this is correct. This is incorrect. So you can see 2 and 3 is the answer. So answer is yes. I think it's asking not correct. Okay, I think 2 4. Yes, 2 4. Yes, answer is B, 2 and 4. So you can see the Advocate General under Article 165. So Chief Law Officer. So already I've explained you details. So please go through. You'll understand it. Okay. So next is which of the following statement are not correct in respect of private member bill introduced in the Parliament. So here OPSC has played a very good tricks with all of us. So so that student will not able to understand it. So a private member is a member other than the minister. Anyone other than minister is called as private minister. Even if they are from the ruling party, they are also private member. So private member is a member of the parliament other than the member of the treasury bench. No, it's not member of the treasury bench. It's only the minister. Other than minister is called private member. Okay, so this statement is wrong. So again, it is not correct. So please, whenever you see in question not correct, highlight it multiple times. Okay, so the bill of this nature are introduced and debate only on the Monday. No, the private member bill introduced only on the Friday. It is not Monday. Okay, so it introduction. So it's not correct. So it's introduction in the House. 1 month notice. Yes, private member bill need 1 month notice to introduce in the House. So a constitutional amendment bill may be introduced either Lok Sabha or Rajya Sabha. Yes, this is right. But I don't know. मैंने ओडिशा ओपीएससी जो क्वेश्चन बनाउछन्ती को हालत रे बनाउछन्ती मैं जानि पानी तो देखो हियर इन क्वेश्चन यू आर टॉकिंग अबाउट प्राइवेट मेंबर बिल हियर यू आर इंट्रोड्यूसिंग कॉन्स्टिट्यूशनल अमेंडमेंट आई डोंट नो हाउ दे आर मेकिंग क्वेश्चन आई थिंक माने कोन कहबी छाड़ो कॉन्स्टिट्यूशनल बॉडी आई हैव लॉट ऑफ रेस्पेक्ट फॉर ओपीएससी सो माने क्वेश्चन बनिया पुरो टिके भाबी चिंती करिया दरकार बिकॉज़ यू आर प्लेइंग विथ इमोशन ऑफ दिस स्टूडेंट चलो so this statement is right, so it's also right, so answer is not correct is asking about not correct, so 1 and 2, so answer is C. Okay, so next important question is which of the following statement are correct in respect of anti-defection law. So you know that anti-defection law basically disqualify legislature, it can be MP or MLA, if they vote against the political party weave. So we have introduced anti-defection law in 52nd Constitutional Amendment Act in 1985. Okay? So anti-defection law found place in Constitution by 52nd Constitutional Amendment Act, right? So 10th schedule of the Constitution inserted Constitution by year, it is wrong. So it is 1985, remember. So here is also there is some wrong also. Here even OPSC is given wrong answer. So the anti-defection law was reinforced in 2002. No, it is reinforced in 2003 by 91st Constitutional Amendment Act. So we have enacted 91st Constitutional Amendment Act, that is what strengthened the anti-defection law. If any member who is independently elected to join any political party, he is not disqualified. No, this is also wrong. Once a candidate is elected as a independent, need to be maintained independent. This is what in case of nominated, he can join any political party within 6 months. But in case of independent, once an independent, always an independent. That means an independent candidate cannot join any political parties. Okay, so answer, I know it should be only one, but I don't know OPSC. I don't know the great OPSC which be there answer. So you can see the 91st Constitutional Amendment Act we have enacted in 2003. Okay, so independent candidate, once an independent, always independent. So you cannot join any political party, but nominated candidate can join any political party after 6 months. Okay, so next, let's see. So which of the following statement are correct in respect of special session of Parliament? So first one is our special, the term special session of Parliament is mentioned in the Article 85. No, there is nothing like that. Article 85 of Indian Constitution talks about summoning and prorogue of the constitutional sessions. There is nothing talk about special sessions. So statement one is not correct. So Article 352 8B Constitution speaks about special sitting of the House of Parliament. Yes, the during emergency there can be special sitting to approve. Okay, so this statement is correct. So the procedure of both House of the Parliament in special session could be limited. Yes, limited to specific provision like approval of this emergency or any resolution. So yes, this statement is right. So if proclamation of emergency issue, Parliament in not session, 1/3 of the Lok Sabha, 1/3 of Rajya Sabha members. So it is not 1/3, rather it is 1/10. Okay, of both Lok Sabha and Rajya Sabha. So that means this statement is also wrong. So only 2 and 3. So answer is 2 and 3. So the Article 85, there is not specifically mentioned about any specific session. Article 85 is talking about prorogue and summoning of the sessions. Okay, so 352 articles it provides for that if proclamation of emergency is issued, it must be approved by the House within 1 month. This may require a special sitting. So if national emergency we impose today, so we need approval of the members. So to approve member, we need special sitting. So next one is about the proceeding of the both House of the Parliament during special sittings are generally limited to specific purpose, such as discussing, approving particular issue, emergency proclamation, specific bill. It is not like in general. It's a very specific. So and 1/10 of this strength we need, not 1/3. Okay. So dear student, everything is okay. So please confirm in the comment box if everything is okay or not. Otherwise, it's very difficult for me to understand. So if everything is okay, please confirm. So next one is about which of the following statement are correct with respect to due process of law and procedure established by law. So due process of the procedure established of law means if we are following the procedure, let's say the law need to be introduced only in Parliament, then it need to be give approval by the Speaker, then let's say then it need to be passed to the Rajya Sabha. If we are following this same procedure, whatever may be the consequences, it is valid in case of due process of law. That means we have followed all the procedure. So by our legislature can pass any law, they can be very regressive, they can even authorize to kill anyone by following the proper procedure. So in that case, our Supreme Court, our court have to accept it. But in case of procedure established by the law, it is not only about the process. We have to follow the process to make the law, but also make this law should be reasonable, fair, and just. That means we cannot, our Parliament cannot make any law that can, take our the fundamental right, which is very sacrosanct. So due process of law is broad concept. You have again this due process of law we have borrowed from American Constitution, and procedure established law we have borrowed from the British Constitution. So procedure established law also called as rule of law. Okay, so the due process of law focus on formal adherence to the legal procedure set by the Constitution. No, due procedure law is beyond the formal, so it's wrong. So procedure established by the law emphasize the protection of individual right, fairness. So we have to reverse it. So this is the function of the due process of law, and this is the functioning of the just they have just reversed. They have just reversed the statement and ask it. So both 1 and 2 are not correct. So due process of law is a fundamental principle. So ensure that fair treatment through normal judicial system. So particularly as citizens interact with the legal system, government. So yes. So and procedure established by the law. So that means we have to follow the defined procedure. So please, you can write due process of law equals to procedure established by law plus law should be fair, just, reasonable. So that means due process of law is very broad. Due process of law is very broad. It includes procedure established by the law, plus law should be just, fair and reasonable. Okay. चलिए आगे बढ़ते हैं. So which of the following necessary for the pressure group to be effective in influencing government policy? So to ensure that that should be influence on the government policy, so what are the procedures? So this is quite subjective, different people having different interpretation, but most appropriate is about money and expertise, because to have what is the main objective of the pressure group? Pressure group wants to put too much pressure on the government to achieve their objective. I think FICCI, I think you know about Federal Chamber Commerce of Industry, FICCI. So FICCI basically want to protect their commercial, the capitalistic interest, and to achieve that. To achieve that, what they need majorly, they need money and expertise. Even if they are very small, they don't have huge large number of people there, but they still influence the government because they have large amount of money and expertise. So access to media outlet is essential, but it is not the sole things. But after you are getting access, what you need is expertise. You need how you can put forth your point. So that is what very important. Okay. So legal support, no doubt legal support is essential, but most important thing is money and expertise. So money and expertise are crucial for pressure group to conduct research, gather data, and develop when informed argument to influence the policy. So if you have put forth your policy in a very systematically logical way, then you can convince the government people, so that you can bring about changes. Okay. So please read it. I've already given a detail. So next one is about which of the following policies are substantive public policies are those which plan and program, get the things done, allocate resources, service to a particular segment of the larger society, directly distribute benefit or cost to the citizen, impose restriction on the behavior. So substantive public policy basically deals with directly distributing benefits and cost of the citizen. So this is what the answer. So plan and program. So this is what called procedural public procedure. Okay. So allocation of resource and service to particular segment. This is what called distributive. And impose restriction on behavior. This is what called regulative. Okay. So substantive policy, they are basically focusing on distributing benefit and cost to the citizen. Okay. So deals with, so substantive public policy deals with allocation of the benefits or cost to the citizens. Okay. So please read, already I've given here. Okay. So already I have said you exactly the same thing. So next important question is which of the following policies provide tax refund on all or part of the poor families social security tax? So this is what called earned income tax credit. Okay. So temporary assistance to the needy family. So assistance can be in the form of subsidy also, na? So food stamp. So food stamp is in an account you'll get a stamp or a number or a coupon. So you can go and give any shop and you can get the food. And that shopkeeper, they can use just like the coupon. I think you get in your phone pay, then Paytm also. That shopkeeper use that coupons to get the money from the government also. So this is not supplementary security income. So this is not, so earn income tax credit. So earn income tax credit is a refundable tax credit for low and moderate income working individual and family, particularly those with the children. So this credit amount depends on the recipient income and number of children they have. It is designed to encourage and reward work as a offer offset payroll income taxes. Eligible individual can risk tax benefit if they not owe any taxes. Okay. So this answer is in earned income tax credit. So next important question is which of the following statement about public policy are correct? A public policy must be general or specific. Yes, public policy can be very general, very broad, like clean India mission. It's very broad, very specific, like digital India, like cyber security policy. It's very specific also. It can be very broad, generic. It can be very specific also. It can be broad. Yes, it can be pan India level, or it can be very specific and narrow. It can be target few section of the society. It can be positive, it can be negative. It can be positive means it can promote the positive things. Yes, it can negative, that means it's not promoting the positive things also. So it's rational or irrational? No. Generally, it is believed that public policy are prepared on the basis of rationality. We cannot make any public policy irrational way. So only 4 is not correct. Okay. So 4 is not correct. Rest everything is correct. So answer is C. Okay. So next important question is which of the following statement are correct with respect to distributive public policy? So distributive means you have to distribute the fruits of the good service to among the people. So first one is Also, this is also known as patronage policy. Yes, this is called patronage policy because we are providing patronage to our people. Patronage means, support. We are providing support to our peoples. So it is meant for specific segment of the society. Yes, it is meant for the specific segment. Like for example, we are providing the foods to BPL families, so it's very specific. So it is concerned with regulation and control of the goods and service. No, it is not. It is not basically aims to behave, control, regulate. Do you think that PDS shop is given for to regulate the behavior? No, there is nothing like that. They are simply helping people. So it required little administrative discretion. Yes. So because all the beneficiary, all the process, all who are going to get already defined in this, the scheme itself. So public policy already distributed on given that. So there is little discretionary power that is being given to the administration. So this is the wrong answer. Rest is correct. So answer is C. So answer is C. 1-3, I think. ठीक है. So this one, I think yes. तीन 3 नहीं होगा, बाकी सब होगा. So A this one. Okay. So next important is, so which of the following article of the Constitution related to fundamental right are not available to the foreigner in India? So there are two kind of articles. So some fundamental right, that is, so there are some fundamental right that is being available only to the citizens. Some of the that is available to the citizen as well as non-citizen. So you have to just remember few articles, that is few fundamental right that is available only to the citizen. So they are, Article 15, so that prohibit discrimination on the ground of, few ground. There is a caste, religion, place of birth, gender. So these are the few restriction on discrimination. So Article 16 also equality in opportunity matter of public employment. So Article 19 is also restricted only, it is available only to the citizen of India. So like freedom of speech, expression, assembly, association, movement, resident and professions. So Article 29 that provide protection any section of the citizen they residing any part of the country, they have right to preserve of their unique language, script and culture. So Article 29 is also protected. So Article 30, so right of the minority to establish and administer educational institute of their choice. So the right that is only available to the Indian citizen. So Article 15, that is prohibition on discrimination on the various ground. Article 16, equal opportunity matter of public employment. Article 19, freedom of speech and expression. Article 29, protection of language, script and culture, right, and Article 30, right of the minority to administer educational institute of their choice. 5 article only available to the Indian citizen. So rest it is available to the both citizen as well as other as well. Okay. So dear student, this is all about a discussion of today last 5-year polity analysis. So we are going to discuss this on a regular basis at 8 p.m. So dear student, if you have any suggestion, any feedback, you are always welcome. Please comment in the comment box. According to your suggestion, we are going to incorporate all the changes and bring it so that it's going to very effective. And it's my promise, if you watch all this video, you will ensure that there should be effective revision of everything. It is not only about the answer ABCD that we are going to discuss here. We are going to discuss about everything on the background also. So please support this video. Please share this video with your friend and please watch till the end. So you'll get a lot of benefits. So if you think that video is very helpful, so please like, subscribe and comment in the comment box. And please do share this video with your friends so that a lot of students can benefit from it. And I'll share this PDF with our group so you can get it from there also. Okay, dear student. Chaliye, bye bye. Take care. Good night. And we'll meet tomorrow at the same time 8 p.m. So I'll meet there. Okay. Chaliye, bye. Bye bye.